Corrections officers were given a tip that he was in possession of a shank. When confronted, he did produce a shank that was approximately 9 inches in length that had a
43094, the State of Ohio versus Sean Parker. Mr. Parker is before the court with his counsel, Mr. Kirby. Ms. Nicholson?
Your Honor, it's my understanding the defendant will be entering a guilty plea as indicted with an agreed recommended sentence to the court of 9 months consecutive to his current prison sentence.
All right. And Mr. Kirby, is that accurate?
Yes, Your Honor.
All right, Mr. Parker, they're telling me you're going to change your plea to the one count of the indictment. Before we get to change the plea, I am required to go over some things with you, okay?
Yes, sir.
How old are you?
I am 51, sir.
How far did you go in school?
10th grade.
Can you read and write?
Yes, sir.
Are you a citizen of the United States?
Yes, sir.
Has anyone promised you how the court would sentence you other than this agreed recommendation to me?
No, sir.
Has anyone threatened you in any way to get you to plead guilty against your will?
No, sir.
Are you satisfied with the representation that you've received from Mr. Kirby?
Yes, sir, under the circumstances.
Okay. Are you currently under the influence of any drugs or alcohol?
No, sir.
Do you take medication that interferes with your ability to understand what we're doing?
No, sir.
I have in front of me a document. This is called a change of plea. On the second page, on the line marked defendant, there is a signature. Did you sign this?
Yes, sir.
Did you read this and go over it with your attorney?
I did.
And you believe you understand what it says?
I do.
This document says you're entering a plea of guilty to one count of possession of a deadly weapon while under detention. That is a felony of the 3rd degree and carries a maximum penalty of 36 months in prison and a maximum fine of $10,000. Do you understand the maximum penalty?
Yes, sir.
You're also subject on this case to a discretionary period of post-release control, which means that upon your release on this charge, the Adult Parole Authority may supervise you for up to 2 years.
Yes, sir.
If you violate that supervision, it can return you to prison for up to 1/2 of this court's original sentence. If your violation is that you commit another felony, you can be returned to prison for 1 year or the period that you have left on PRC, whichever is longer, and that time would run consecutive to any additional prison time that you get sentenced to. Do you understand that?
Yes, sir.
Now, you are presumed innocent of this charge. You cannot be sentenced or punished unless you plead guilty or you're found guilty following a trial. Do you understand that?
Yes, sir.
You have the right to trial by jury. If you want, we will impanel a jury of 12 people and require the prosecutor to present sufficient evidence to convince each of the jurors of your guilt beyond a reasonable doubt, or the jury is required to find you not guilty. Their verdict must be unanimous. Do you understand that?
I do.
At that trial, you have a right to see and hear all the evidence that the state has against you. With the help of Mr. Kirby, the right to confront and cross-examine each of their witnesses. Do you understand that?
Yes, sir.
You have the right to call witnesses on your behalf and in your defense. If any of those witnesses are reluctant to come, the court can force them to come by way of subpoena. That's your right of compulsory process. Do you understand that?
I do.
You have the right to remain silent. At your trial, you cannot be forced to testify against yourself. The prosecutor is not permitted to call you as a witness. You can choose not to testify in your own defense. If you don't testify, that will not be used against you, and I will instruct the jury that they are not permitted to infer your guilt nor anything from your silence. Do you understand that?
I do.
Now, the burden of proof is on the prosecutor. At your trial, you're not required to call any witnesses nor present any defense, and if you do not, that will not be held against you. Do you understand that?
I do.
The standard of proof is beyond a reasonable doubt. That standard applies to each of the essential elements of each charge from the indictment. Do you understand that?
Yes, sir.
Now, you could also waive your right to a jury trial, maintain all the other rights we've discussed. You could try your case to the court. I, too, would have to be convinced of your guilt beyond a reasonable doubt or would be required to find you not guilty. Do you understand that?
Yes, sir.
Do you believe you understand each of these rights we've discussed?
I do.
You understand that when you enter a plea of guilty, you'll be waiving all these rights. We will not have a trial.
I do.
That's how you want to proceed.
Yes, sir.
Ms. Nicholson.
Your Honor, if this case had proceeded to trial, the state would have proven beyond a reasonable doubt that on or about April 14th of 2025, the defendant was incarcerated at the Warren Correctional Institution in Turtle Creek Township, Warren County, Ohio, on charges or convictions for felonious assault, a felony of the 2nd degree, amongst others. Corrections officers were given a tip that he was in possession of a shank. When confronted, he did produce a shank that was approximately 9 inches in length that had a 3-inch blade.
Mr. Kirby, anything on those facts?
Nothing on those facts, Judge.
Mr. Parker, did you hear the statement that she read?
Yes, sir.
Do you admit and acknowledge that what she said is true?
To a certain extent, yeah.
Well, to what extent?
That it wasn't a shank, it was a screwdriver on a radio that I was fixing, and the radio was on the desk when the officer came in, apart. And that's the only reason I had it, but I wouldn't per se shank screwdriver. But under the circumstances, it's contraband, which is why I'm pleading guilty to contraband.
Judge, we'll stipulate that the elements of the offense have been described by the prosecutor. We might have some discrepancies in the characterization of the facts, but we would stipulate.
That the facts are sufficient to meet all the elements of the offense?
Correct.
Okay. And again, Mr. Parker, you understand all the rights you're giving up entering a plea of guilty?
Absolutely.
And what is your plea?
Guilty.
All right, the court will make a finding then that you've made a knowing, intelligent, and voluntary waiver of your constitutional rights that we discussed. The court will accept your plea of guilty, and based upon the statement of facts in your plea, the court will make a finding of guilty. Sentencing, Ms. Nicholson, anything?
Your Honor, we just ask that you adopt the agreed in 9 months consecutive to his current prison sentence, which I believe is due to expire in 2028.
Mr. Kirby?
Judge, that's right. The expected release date is March of '28. This is my client, at least his second prison number. He's never been wrapped up in anything like this. He acknowledges it was a mistake. He wants to put it behind him. That's all, Judge.
Okay. Mr. Parker, anything you want to say?
No, sir.
All right, the court has considered the statements made here today, the purposes and the principles of sentencing, the relevant seriousness and recidivism factors. The court has also considered the agreed recommended sentence of the parties and finds it to be an appropriate sentence. So I'm going to order you to serve 9 months in prison, that to be served consecutive to your current sentence. The court finds the consecutive sentence is necessary to punish this defendant is not disproportionate to the conduct or danger posed by the defendant, and this offense occurred while the defendant was already committed in the custody of the Department of Corrections. You have 0 days jail time credit on this 9 months. The court finds that you're indigent for the purpose of any fines, costs, or other financial sanctions. Now, you're also subject to this discretionary post-release control. Do you want me to go over that with you again?
There's no need, Your Honor.
Okay.
Appreciate it.
Okay. You have a right to appeal the court's decision of your sentence to the 12th District Court of Appeals. If you want to appeal, you must file your notice of appeal within 30 days of today's date. If you can't afford to pay for the transcript or anything necessary for your appeal, that can all be provided to you at no cost. If you cannot afford an attorney, I'll appoint one for you at no cost. Do you have any questions for me, sir?
No, sir.
All right, best of luck to you.
Thank you.
Thank you, Judge.